Hello everyone, I am Ankit and you're watching Study IQ IAS English channel. Now, field of polity and law is very dynamic in nature because you understand the supreme law of the land, Constitution of India. It provides individual with rights, what is known as fundamental rights. And Constitution of India also delineates the power between the different organs of the government. For example, the legislature, it is responsible for bringing or enacting the laws. Similarly, executive or the government, it is responsible for implementation of the laws. Whereas if any dispute happens between these two bodies or any dispute happens between legislature and people and government and people, this dispute is arbitrated and settled by the judiciary of our country, because judiciary is ultimate aim and interpreter of the law in India. So if any dispute happens regarding any provisions of the constitution or any law that has been passed by the legislature, that is ultimately settled by the courts in our country, particularly the apex court or the Supreme Court of India. So any Supreme Court judgment automatically is a very landmark judgment that can change the way we interpret the constitution. So in our today's discussion, we'll be covering an important judgment of the Supreme Court of India known as Kedar Nath Singh versus State of Bihar, and this judgment was passed in the year 1962. What issues that this judgment involved, what kind of a judgment did Supreme Court of India give, all of this I'll discuss in our today's session. Now the notes for this today's session, if you want to download them, these will be available on my Telegram channel, ATS Live. So you can search the words ATS Live on the top right hand corner of your app, or you can also have an option to scan this QR code. This will take you directly to my channel. Subscribe to it. You'll get the notes there. Now let us start by understanding the context of this discussion. This notable Supreme Court judgment, it dealt with a person known as Shri Kedar Nath Singh, who was a wealthy zamindar born in the city of Barauni, located in the Begusarai district of Bihar, and he was born in 1930. Now, Kedar Nath Singh's first tryst with law and order, it started when he was just 14 years of age in 1927, where he joined a group of protesters and was subsequently involved for dismantling the rail track, and therefore he was also arrested by the then police. Now, he was charged with disrupting the movement of British-run trains, and he was discharged and released from the prison after a few months, and after which he received a hero's welcome in his hometown. But today we are not discussing about this particular issue, because we are dealing with an issue which happened in independent India. Because Kedar Nath Singh, he showed his determination once again when he was in his 40s against then government led by Congress, as he was charged with sedition for that, because he gave a fiery speech against then Congress government in the Bihar's Munger district back in 1953. So this case deals with this particular incident which happened in 1953. Now, what happened in this incident? Mr. Kedar Nath Singh, what he did, he had a very close attachment with the then communist organizations known as Forward Communist Party, right? So he was giving a fiery speech in Munger, and he was convicted with the sedition and inciting public mischief because of his speech, in which he criticized then Congress Party, and also he criticized their capitalistic policies, and while doing so, he advocated for his own political party, that was the Forward Communist Party. Now, while making his speech, Kedar Nath Singh, he referred to CID officers as dogs of the government and called then Congress Party members as the Gundas. Right, and he openly advocated for a revolution that would overthrow the capitalists, that is Congress Party, aiming to establish a government for the poor and downtrodden. And while doing so, he also criticized Vinoba Bhave's Bhudan movement, that was essentially a land distribution efforts. So because of his speech that criticized the government officials, that criticized the ruling party, he was charged with the charges of sedition and inciting public mischief. Right, so this was the background of our today's discussion. Now, because of this statement, the government levied the charges under section 124A of the Indian Penal Code, that was sedition, and section 505, that was public mischief of the Indian Penal Code. And because of these charges, he was sentenced to 1 year rigorous imprisonment by the district court. So naturally, Kedar Nath Singh, he appealed this conviction in the Patna High Court, but Patna High Court upheld the decision made by the district court, and the Patna High Court responded that Singh's speech was not merely a criticism of the government, but it was a direct vilification of the government filled with incitement to revolution and sedition. So when Singh, according to the Patna High Court, was demanding revolution, he was inciting violence against the government. That is why this charges of sedition and public mischief was indeed correct on Kedar Nath Singh. Now, what is the option available against any decision made by the Patna High Court? Naturally, you can go to Supreme Court. Similarly, this was what Kedar Nath Singh did. He further appealed the decision made by Patna High Court, and this reached the apex court of our country, that is Supreme Court of India. There, Kedar Nath Singh, he argued that the sedition provisions in the Indian Penal Code, it actually violated his right to freedom of speech and expression, which is covered under Article 19 of the Constitution, right? If you read Article 19 of the Constitution, it provides Indian citizens right to freedom of speech and expression, which means you are free to express anything, including the criticism of the government. So, according to Kedar Nath Singh, this sedition provision and public mischief provision, which was levied to him and also resulted into his conviction, this was indeed unconstitutional because it violated his fundamental rights provided in the Indian Constitution. But given this was a constitutional question which involved Supreme Court to consider many constitutionality of different provisions of the Act, this matter was referred to a constitutional bench. What is a constitutional bench? If any bench or any matter, if it is heard by equal to or more than 5 judges of the Supreme Court, this is called as a constitutional bench. And this was sent to a constitutional bench because Supreme Court had to reconcile conflicting judgments from the previous case, and if they had to be overruled, this judgment needs to be given by a larger bench. That is why it was referred to the constitutional bench. Now let's see what was the provisions that was considered in this particular case, that is Kedar Nath Singh versus State of Bihar case 1962. First, this dealt with 2 sections of the Indian Penal Code. First was section 124A of the Indian Penal Code, which defines an offense of sedition. Now this includes any speech, written or verbal, if you make, and this speech, if it attempts to bring hatred and contempt or excites attempts to create violence against the government, this is called as a sedition under section 124A of the Indian Penal Code, which was an erstwhile act. Similarly, section 505 of the Indian Penal Code, it dealt with creation of public mischief, where any rumor or any statement or any speech that you give, and it focused on statements that may incite public disorder, fear or alarm. It might be true or it might not be true, but if people conduct violence, then people who are under section 505 responsible, they will be charged with sedition under section 124A, and these 2 charges were indeed levied on the Kedar Nath Singh, right? So this was considered by the Supreme Court. Another provisions that were considered by the Supreme Court were provisions mentioned in the Supreme Law of the Land, that is Indian Constitution, because if you remember Article 19(1)(a) of the Indian Constitution, it provides every citizens to have freedom of speech and expression. But this is not an absolute right. This is a qualified right, because government under Article 19 subsection 2 has the ability to impose what is known as reasonable restriction on the citizens of India in exercise of this particular right of freedom of speech and expression, which means state can impose reasonable restrictions on right to freedom of speech and expression in interest of sovereignty and integrity of India, in ensuring security of the state, ensuring friendly relations with foreign government, ensuring maintenance of public order, decency or morality, and also in relation to contempt of court, defamation and incitement of offense. So these are the grounds which qualify for imposing some restrictions on the exercise of freedom of speech and expression. That is why, please remember, this is not an absolute right. Rather, this is a right which can be restricted in certain cases. These are the instances where it can be restricted. Okay. So, in front of Supreme Court, there were many issues. First was it had to decide whether merely using just a strong or harsh language against the government, will it qualify to be called as a seditious act, or there is a clear intent or potential to incite violence or public disorder, then it will qualify for a sedition act. Therefore, what Supreme Court had to do, it had to determine what kind of speech is a permissible criticism of the government and what kind of a speech will prove punishable under the Sedition Act. Therefore, it had to understand intent or tendency to incite disorder in order to call it as a sedition. Another thing that the Supreme Court had to do or consider was the constitutionality of sections 124A and 505 of the Indian Penal Code. Whether in bringing these legislations have the government imposed reasonable restrictions or not, or whether these restrictions that are imposed on people are unreasonable in nature. So if they are unreasonable in nature, if the Supreme Court finds them unreasonable, this means they will be declared as constitutional and void against the Indian Constitution. So this has to be determined by the Supreme Court, that whether these actually act as a reasonable restriction or not. So these were the matters that were considered by the Supreme Court in this particular case. Now let's see what was the judgment of the Supreme Court. Now Supreme Court, upon giving the judgment in the Kedar Nath Singh versus of State of Bihar case in 1962, it upheld the constitutionality of section 124A, but it narrowed the scope of how to apply section 124A significantly. In doing so, the Supreme Court said that only speech that incited violence or had an intention of creating public disorder, this can only be punished as a seditious act. And if you're just criticizing the government, however, you're using a stronger and inflammatory language, it does not constitute a sedition. So only if you have an intention to incite violence and create public disorder, then only that act will be called as sedition, and then only you will be punished under section 124A. So what the Supreme Court is saying, it actually held that constitutionality of section 124A and 505 was indeed constitutional because it was consistent with the requirements of Article 192, which meant Supreme Court found out that section 124A and 505, they actually amounted to what is known as a reasonable restrictions. And therefore, it was constitutional and it was not struck down by the then Supreme Court. Also, Supreme Court highlighted that you need to protect the government and state because state is a concept in political science and government in itself, in practice, it is the embodiment of state in real form. So disloyalty or enmity, when you extend it towards government, it implies a tendency towards creation of public disorder, inciting violence or actual violence. Therefore, you need to have a certain penal statute in your law so that people who are involved in inciting public disorder or creation of violence against the government, they can be punished. And therefore, they held these section 124 and section 505 of IPC, they were indeed constitutional in nature because it gave power the state to prevent of disruption of public disorder and prevention of violence against the state. But while doing so, Supreme Court also balanced individuals' freedom of speech and the state's requirement to uphold public order, because Supreme Court said citizens are free to criticize the government and its policies as long as they are not inciting the violence or disturbing the public order. Therefore, it was the court responsibility to delineate what is the clear boundary where you can criticize the government without calling for a violence. And if you call for violence, the legislature should have the authority to impose reasonable restrictions, which it has done so by enacting sections 124 and section 505. Okay. Now let's see what are the recent developments relating to the provision of the sedition, because you understand we were dealing with Indian Penal Code. Now government has revoked Indian Penal Code and brought a new law, Bharatiya Nyaya Sanhita. So let us see what is happening currently. Now in 2022, while hearing the challenge on the constitutionality of the sedition provision, that is section 124A, the Supreme Court actually stayed the operation of sedition law, holding that it was prima facie, at the look of it, it was unconstitutional. But the government of India then, it requested an opportunity to rethink the law before court could actually held that it is unconstitutional and void. So what the government did, it brought a new law known as Bharatiya Nyaya Sanhita, which introduced and repealed the erstwhile Indian Penal Code. And while doing so, Union Home Minister Mr. Amit Shah announced in the parliament that the colonial sedition law has indeed been repealed. But if you look at the law, you will see that the Bharatiya Nyaya Sanhita, it retains the text of the law that was of section 124A also known as Sedition law of IPC. While it mere changes the name, earlier the word Rajdroh was there, which meant treason against the empire, and this term Rajdroh has been changed with Deshdroh, which means treason against the nation. So the provision, it stays in the Bharatiya Nyaya Sanhita. However, it is not given the name Rajdroh because this was termed as a treason against empire, because this was a law passed by the colonial government, right? But now when you have passed a law, you can only be punishable if you are involved in Deshdroh, which means treason against the nation. So this does not mean treason against the government. Understand? So this is the recent development regarding this particular law. Now let's see why this case was so important. Because in this Kedar Nath Singh versus State of Bihar case, the Supreme Court reaffirmed the importance of dissent and criticism in a healthy democracy. Because what is healthy democracy? You yourself elect the government, and you should have the ability to criticize any provision or any policy of the government without being in fear of creation of law and order problems, or without being fear of getting imprisoned for that. And that is what the beauty of democracy is. That is, you can criticize the government and this cannot be deemed seditious unless or until you are inciting violence or creating public disorder. And therefore, this balance protects the democratic ethos and ensures vibrant political discourse. Because otherwise, if the government has this ability, because if you criticize the government would imprisonment you. So how will you ensure the existence of opposition parties? How will you ensure existence of dissent in a democracy, right? So this is essential for the progress and stability of nation as a whole and our political structure as a whole. And also, by setting clear parameters for the application of sedition law, this court not just protected individual liberties but also reinforced the principles of reasonable restrictions. That no restrictions, just you can't impose any restrictions on the exercise of freedom of speech and expression. Those reasons or those restrictions should be reasonable. It can only be done so in case you are creating violence or you are creating public disorder. But when you are using harsh language against the government without asking people to commit violence, that is not a sedition, right? So therefore, it ensures that state power is exercised judicially within the court or within what is permissible in the laws, right? So this is why this court case is very important. Now let's see if you are able to solve this particular question. Why I have curated this question? Because in 2018, a very famous judgment was given by the Supreme Court of India known as Puttaswamy case, right? And in this Puttaswamy case, the Supreme Court highlighted that right to privacy is a part of Article 21 of the Constitution. So this question was asked in the UPSC in 2018, and I have changed that question somehow to fulfill the need of our today's discussion. So please let me know the correct answer to this question in the comment section. And if you want to download the notes for this session, this is again available on my Telegram channel, ATS Live. So go to that channel, subscribe to the channel and download the notes. And I think I've completed our today's session. So please do not forget to answer the correct answer for this MCQ in the comments, and I'll see you again. Until then, please have a very good night. Okay.